Good afternoon, everybody. My name is Eric Hauge, and I am the Executive Director at Homeline. And you're joining us on Wednesday, June 3rd at 1:30 in the afternoon for another one of Homeline's sessions regarding tenant landlord law in Minnesota during the COVID-19 pandemic. Today, we're joined also by Homeline's Public Policy Director, Michael Dahl, as well as our Managing Attorney and Tenant Hotline Director, Mike Vraw. And we're going to go into some discussions about the current status of the eviction suspensions, both on a state and federal level. Share some news, albeit unfortunately somewhat limited, on things going on at the legislature, Minnesota legislature, around the policy that would create an off-ramp or an end to the eviction suspension. And then also sharing some news about the federal CDC suspension and some recent litigation and court rulings around that. Before we do that, we're just gonna do some quick logistical things. Again, we've been doing these sessions since mid-April of last year, and we're glad you're joining us. I'm sure a lot of folks have tuned in before, but a reminder about what Homeline is in case you're new. We're a statewide nonprofit organization. We provide free legal, educational, organizing, advocacy services for renters. Our main program is a free and confidential tenant hotline that has advised over 265,000 now since 1992. And we serve folks in 4 languages: English, Spanish, Somali, and Hmong languages. There's our hotline number. You can also reach us on our website and send an email to one of our attorneys on our website. And we are planning to continue these sessions for the foreseeable future. We took a few weeks off, and we decided to come back today because we thought there might be some news around the eviction suspension off-ramp. And there's a little bit, and we'll share that soon. We can't really predict when there is going to be news. That would be, I think Mike talked about that I should order a crystal ball during the last session, and maybe we could do a better job of that, but we just can't predict what's going to happen. And so we've got a couple more sessions scheduled this month, one in just a week away. And the reason for that is that the current suspension ends next Monday. And there's already been some reports that Governor Walz is going to extend it, but the Minnesota legislature will come back next week and be discussing a number of items during this special session, and we'll hear more about that later. But we don't know what will happen, but there may be some news next week, and so that's why we're having one next week. And then at the end of the month, there's a lot happening on the 30th of June. It's the last day of the month, obviously, but 2 other key things happening on June 30th. One, that is the current timeline for the federal CDC eviction moratorium to expire. So there may be news by the 30th about if that's getting extended or what's happening in the courts regarding that. And then secondly, June 30th is the end of, I believe, the Minnesota state fiscal year. And so the legislature, that's sort of like a looming deadline for the state legislature, is that they have to have a new budget for the next biennium beginning July 1 at the end of this month. And so there may be news on that, and that might be related to the off-ramp. Somebody asked what off-ramp means. I'm not sure that who came up with that term, but it effectively is a term for some sort of policy that gets set up in advance of having the federal and or state eviction suspensions or moratoriums come to an end. So sort of a ramping off of the moratorium, and that would potentially create a situation where more evictions would be filed. So that's sort of what that's at. And we'll talk about that in a little bit. Yes, somebody's also asked about if people are on mute. This is a webinar format, so you're on mute. And Let's see here. Just a couple, I guess, a couple logistical items before we get started too, is that we did get, we always welcome questions during these sessions. We do have some prepared remarks at the beginning here that Michael and Mike will go through. We did get some questions, maybe a half a dozen or more in advance. We'll tackle those. And if you have a question about anything, go ahead and that we talk about, or a specific question about something else regarding tenant landlord law in Minnesota, feel free to submit it, preferably over the question and answer system in Zoom. And we will get to those at the end of the session. We'll leave room for that. All right. And we want to just remind folks before we get started again is I think a lot of folks are aware of this program. This is a statewide emergency rental assistance program that started in mid to late April, and it's still running. It's statewide. If you are behind on rent because of the pandemic in some way, go to renthelpmn.org or dial 211. You can apply online, or you can get paper application to send in. There's also a new rental assistance program. I apologize for the font here, but a new rental assistance program was just initiated earlier this week. It's called the Zero Balance Project. It's only for residents of Dakota, Hennepin, and Ramsey County, which includes Minneapolis and St. Paul. And this is a little bit different program. Some of the eligibility is somewhat the same as Rent Help MN, but sort of the difference here is that the Zero Balance Project is initiated by property owners, managers, landlords. They start the application and provide much of the materials. A tenant is required at some point to enter in some information about their income and demographic information. But it's a new program, and it's a temporarily limited, at least for now, until funding runs out. It started, I think, on Monday and runs until the 20th of June. So just an option for landlords who maybe are having trouble getting applications through. This is another option in these counties, Dakota, Hennepin, and Ramsey. Okay, that's enough for me, I think, right now. Right now, we're going to hand it over to Mike Vraw to cover some of the suspension rules. Thank you.
Thanks, Eric. And I'll be talking on this first slide, then handing it over to Michael Dahl, the Public Policy Director, for the next slide. But what I'm going to start with here is a quick snapshot of where we are with the Minnesota rule that we're talking about here. So the headline of this slide is slightly misleading. When will Minnesota evictions be filed again? What it really should be asking is, when will non-payment of rent Minnesota evictions be filed again? Because that's what is really the critical question when it comes to this eviction moratorium that we're talking about. Evictions in Minnesota are almost all filed for non-payment of rent. At least that's historically what they've been. Over 90% of evictions are filed for non-payment of rent cases. So the tenant hasn't paid the rent, the landlord is upset, and they go ask a court to remove the tenant. That's really what an eviction is about in Minnesota, and almost all of them are for non-payment of rent. There are other reasons, of course. The tenant has an unauthorized occupant, they have a pet and they're not supposed to, they have a loud party. Those can all be evictable breaches of a lease as well, but non-payment of rent is sort of the driving force behind the eviction process in Minnesota. And so that's really what we're asking. When will non-payment of rent evictions in Minnesota be available for landlords once again? At present, they aren't, and they haven't been since March of last year. So every month, the governor has been renewing what's called a peacetime emergency. And these peacetime emergency declarations, these declarations only last for 30 days at a time by law. So if the governor wanted to do a 1-year peacetime emergency declaration, doesn't have the authority to do it under the statute that gave the peacetime emergency powers to the governor. They have to be 30 days at a time. Now, if it's during a legislative session, the 30 days can be renewed again and again and again. The legislature has the chance to act to stop it during the legislative session. But the next time that we see a renewal, which would be next week, if the governor does decide to renew the peacetime emergency for another extension, the legislature is not currently in session. And so we're back to the same thing that we ran into last summer, which is where the peacetime emergency rules, if the governor reauthorizes another 30 days, It's an automatic special session trigger. Now, those of you that have followed Minnesota politics to any degree over the last decade or so, or 2 decades, would have seen lots of special sessions. You wonder if they're just kind of part of the deal. Do we always have a special session? In short, no, there's no requirement that there's a special session. They've typically been about budget fights. And that's true to some extent as well this year. But when this special session is triggered, then the legislature has the chance to once again end the peacetime emergency that we're in. Now, to do that, both chambers of the Minnesota legislature would have to vote to end the governor's peacetime emergency powers. So the governor is a Democrat, DFL party, Governor Walz. The Republicans have the majority in the Senate. And every time they've voted on this issue, whether to end the peacetime emergency powers of the governor or not, they have voted to end the peacetime emergency powers. I don't remember when the first vote occurred on that, but it was certainly last year, and I think last summer, might even been during the legislative session last year, but it's been a long time, and they voted several times to end the governor's peacetime emergency powers. But that's not enough. The Minnesota House would have to vote to also end the peacetime emergency powers that the governor continues to renew. The Minnesota House has a majority of Democrats, and every time they've voted, they have voted to not end the peacetime emergency powers. Now that vote has shifted. The actual numbers of votes in the DFL column and the ones in the Republican column have shifted over time. But I don't know that there's any sort of consistent trend that we can glean from what we've seen in the last few times that we've had a vote. So when will this be ended? Well, the governor's moratorium on the evictions could be ended in one of 3 ways, I think. The first is the governor could just stop renewing the peacetime emergency extensions, or could say, you know what, I still need the peacetime emergency powers because it's not just about evictions. But I'm going to end the eviction moratorium. I'm going to stop doing that. The governor could do that unilaterally. Next up would be the legislature ending either one or both, I suppose, of these. But I'm not sure that they could end the eviction moratorium without ending the peacetime emergency declaration powers. I don't know about the logistics of that, but regardless, the legislature does have the power to stop the 30-day renewals of the peacetime emergency. The last way it would end is if a court says that it needs to end. So far, all the court challenges against the peacetime emergency powers and the eviction moratorium in Minnesota have been unsuccessful. So that's why we still have it in place. Why we still have the peacetime emergency declaration, why we still have the eviction moratorium in place is because the governor keeps renewing it. The legislature doesn't stop it, nor does the court. So it goes on month after month after month. As Eric mentioned, we've gotten early indications that the governor is planning to renew the peacetime emergency another month. Michael's going to talk a little bit about the legislative specific conversation about the eviction potential compromise between both parties. But where we're at practically right now, June 14th is the end of the peacetime emergency. That would be the end of the eviction moratorium. We've said that same thing every month since last March, though, basically. And so we never know until that day comes. And sometimes it's announced that day officially. That's the official day they make the declaration anyway. But sometimes it's announced the day before or the morning of. It varies a little bit, but it's usually fairly last minute. It has been. And so that's what we're assuming will happen again, is that it will be once again a last minute sort of statement from the governor and then the official action taken by the governor. Okay, so that is the nuts and bolts of where we're at with the state eviction moratorium. Now I'm going to turn it over to Michael Dahl so he can talk about some of the workings at the legislature to maybe come up with a compromise.
Thanks, Mike. And the general story here is that not a lot has changed since the last time we had this webinar. There have been negotiations between the House and the Senate, but they, jumping to the punchline really quickly, have not produced a lot. The regular session ended on the 17th without an agreement on the eviction moratorium off-ramp, and on June 4th was a deadline to try to resolve policy issues to get passed. That did not come up with a resolution as the House and Senate and the governor had hoped for. And so what happened is the the committees that were handling housing issues let leadership know, Speaker Hortman, Majority Leader in the Senate, Gazelka, and the governor's office know what the sort of the parameters of what their agreement was at. And the likelihood is that if there is a resolution in anywhere in the near future, that it would come out of a negotiation amongst leadership, those three parties, rather than the committees that have been actually working on this. Now, it's possible a deal could get made before the governor calls the next extension, but at this point, it's unlikely. That doesn't to say that there hasn't been some work. There have been some private volleys back and forth about potential compromises that could take place, but in the last few rounds, it's actually taken a turn for the worst as far as seeing an end to the moratorium as things have gotten more complicated. And I don't want to get too much into the details because they're all sort of rumors, but the Senate is holding strong on its position while the House has come towards the Senate on some issues, but then in other areas not. So the House and Senate versions are vastly different. Where they are similar is that they would both add material breach of lease for exceptions for reasons to evict. However, the House has a more tenant-friendly definition of what a breach of lease means. Both have, at this point, differing timelines on when things occur. And when we talk about an off-ramp, a healthy off-ramp has a orderly procession, hopefully, of people where not all evictions happen at the same time. And so the House and the Senate have different versions of when certain people would begin their way off the off-ramp, onto the off-ramp, and they have not come to resolution in those areas. And then lastly, is there's contrasting guidance on notice, whether or not a landlord needs to provide notice to their tenants for unpaid rent. And also the eviction when rental assistance is pending. There's differences there, but what's important to note is that both parties have language that says that pending applications in most circumstances would keep a tenant from being evicted. So if you're a landlord or a tenant that wants to get help from renthelpmn.org, it's really key that you start that application as soon as possible, because both the House and the Senate have some version of a notice of a exceptions that say that you cannot be evicted if you become that process. And that's where things really stand right now. There's a lot of rumors going on at the Capitol about where things are at behind closed doors, but those sort of change day to day. And so it's kind of hard to answer questions like, when will the off-ramp end? Well, it depends on who you're talking to at any particular moment. And then other portions of the eviction moratorium. Similarly, rumors abound. But for now, what we're most likely to see is the governor's extension of the peacetime emergency and the moratorium continuing with that. And so with that, I'll turn it over to Mike, and I'd be happy to answer any questions as we go along in this process.
Quick question, Michael. So you mentioned that rumors abound. I suppose the worst thing that we'd hear would be that there are no rumors, right? There are still rumors happening. There still seems to be activity behind the scenes.
There's activity behind the scenes. However, the latest activity from there was a press conference held earlier today by some House conferees and advocates for housing issues. And it was noted at that press conference that the Senate has actually they don't just want the eviction moratorium, they want their position on funding for affordable housing programs and bonding for affordable housing to be their recommendations as well. And so they're mixing issues. And so the rumor tells us we're further apart than we've been before. And that's an unfortunate turn of events.
You mind if I jump in quick, Mike?
Jump on in.
Yeah, I was just gonna say, this isn't really a question, but I know we've gotten a number of questions that were submitted in advance and some over the chat and stuff, asking about, when is the money gonna come? What, a tenant applied for rent help MN. We're hearing both from tenants and landlords that that their tenant has applied and they're waiting. Unfortunately, that's not really what we can answer right now. And we haven't really tried to answer that in the past either. We've tried to provide resources like and links and information about Rent Help MN and this new Zero Balance project, but we unfortunately are not associated with the programs and can't really answer questions about somebody's application. You really need to either go online and check your application there, or 211 is the number you can dial, and I believe they can connect you. They can either answer some questions about applications, or they can connect you to a partner organization that's doing those things. We are not, but we are referring a lot of folks to those programs, and this is really one of the reasons why we've sort of been consistent around saying there needs to be a process that ensures that program and other those are not the only rental assistance programs people are applying to right now to get caught up on COVID-19 related rent arrears, and it just takes time, and so people need the time to get that funding, and even though it's taken a month or two or more, that's part of what a reasonable off-ramp should work. Okay, that wasn't a question, but I wanted to just answer, respond to it because we've seen some questions around it.
Eric, if I can just make one point, you sort of began to touch on it right then. Homeline believes that an eviction off-ramp should be less about when evictions can start and instead about when money becomes available to those who apply or are trying to apply for assistance. And so you can sort of take the eviction approach, or when is this assistance going to get out? And we hope that both sides of the aisle continue, or both the House and the Senate continue to allow for not doing evictions for non-payment of rent when applications are in place. We would also put people who are trying to apply as part of that answer as well. And I'll turn it over to you, Mike. Is it you?
You're muted, Mike.
You're right, I am muted. Yeah, so next we're going to talk about the federal moratorium on evictions. This is routed through the CDC. That is the agency that came up with the federal eviction moratorium. And there has been some substantial news in this department since our last speech, which was in late May. So just to recap where we were then, at that point, the district court federal judge in the DC circuit had ruled that the CDC moratorium on evictions was in fact not allowable. So I'm not going to say constitutional, but just not allowed. And then had immediately granted a stay pending an appeal of that injunction that the federal judge had issued. Now, the circuit in DC is generally considered the most important circuit at the federal level. Some people call it the second most important court in the country. Other people call it the first most important court in the country because of the volume of cases they hear versus the US Supreme Court. The US Supreme Court hears 75 to 150 cases a year. They get applications, requests for cases in the number of about 7,000 a year. So they hear somewhere between 1% and 3% of cases that are filed there. But the DC circuit hears a lot of cases where there's kind of state or circuit conflict, I'm sorry, where one circuit is decided a case in one direction and a different circuit decides it in another direction. And so it's seen as kind of this primary circuit court. It's kind of a launching pad for the US Supreme Court. I think there's 4 justices on the Supreme Court that were at one point judges on the Court of Appeals at the District Court, the DC Circuit. And so it is, I think it's safe to say, the most important Court of Appeals level to have a case heard at. It's not the only one, and that's not always true, but that's kind of a generalization. So anyhow, the government had appealed, of course, the district court judge's ruling that the CDC moratorium was not allowable under its original charge. And the Court of Appeals disagreed with the district court judge. So at present, the injunction is stayed pending the full appeal. And the Court of Appeals found that the CDC has made a strong showing that it's likely to succeed on the merits, and really stopped analyzing deeply once they found that in their decision. I've read the decision a couple of times. It's thick, it's very well written, as was the district court case. It was well thought through as well. This reminded me of something that law students see when they're in law school, of a moot court kind of problem. What do I mean by that? Well, moot courts try to find arguments that they think, these are practice courts for law students so they can get ready for being attorneys when they're done with law school. And what they try to find are issues that there have been contrary decisions in the law, and decent arguments on both sides. And so it reminded me of reading a moot court kind of setup for an issue, that we've got this DC Circuit Court ruling now, which very strongly favors the government's argument. We've got the district court ruling, which clearly was leaning in the landlord's direction. There have been nearly a dozen other cases around the country as well, offering opinions, and it's somewhat split on whether the CDC has the power to have this eviction moratorium in place. So will the Supreme Court hear this case? That's what's happened next, is the Alabama Association of Realtors, a landlord group, not just a landlord group, but a landlord group, and they're the ones spearheading this case and started the case, has asked the Supreme Court to hear the case. And I believe the government has until tomorrow, June 10th, to submit their counter argument to what the landlords have submitted, which once again was very thoroughly thought through. This isn't amateur hour stuff. This is high level work that's gone into all of these things that I've read, certainly in the Alabama Association case. There was a case in Texas from a federal judge that just seemed a little bit flippant to me, and didn't have the same gravitas that these cases that I've been reading really seem to have. These are thought through decisions. These are thought through appellate motions and arguments. And will the Supreme Court hear this case is a very fair question. I mean, we don't know, first of all, whether President Biden or the CDC is planning to extend the eviction moratorium through the CDC past June 30th. That's when it ends. But that is very broad. It says that no non-payment of rent evictions can be filed throughout the United States. Tenants have to meet some qualifications. Their income can't be too high, which is over $100,000 a year per adult, up to $200,000. And they have to submit an affidavit of, well, not an affidavit, a sworn statement, more or less, indicating that they've tried to qualify for financial assistance, whatever financial assistance might be eligible for them. But apart from those two key factors, the tenant really can't be evicted for non-payment of rent. Now, the CDC moratorium hasn't meant much in Minnesota because the CDC federal moratorium explicitly defers to the state moratorium if it offers more protection to a tenant. And in Minnesota, that's clearly true on almost every case. For instance, a landlord is not allowed to non-renew a tenant in Minnesota. It's not just that they can't file an eviction, but they can't simply decide to not renew the lease at present under the eviction moratorium that we have in place. And so there is more protection at the state level. So the CDC moratorium hasn't meant that much. But what it has meant to Minnesota renters and Minnesota landlords is that there's this federal backstop in place. Now, the latest CDC moratorium period that we're in ends June 30th. It started on April 1. Our first period started in September, went through the end of December. Then there was a 1 month renewal, more or less, followed by January 31st to March 31st, and then the April 1 to June 30th. Before the period that we're in right now, so the April 1 through June 30th, the rumors were strong that the president was going to extend the CDC eviction moratorium through September of this year. And there's still a reason to think that that might happen. But again, the Supreme Court could step in and say, yeah, let's hear the case. Let's hear it on an expedited basis. They can hear cases really fast if they wish. They kind of make their own decisions and do what they like. And so that's always a possibility that the Supreme Court could step in and say, we want to hear this. We want to decide it. This is a matter of national importance. And so we're going to hear the case. They could not hear the case. They could decide not to as well, which is always the odds on bet. Again, 97 to 99% of the cases where people ask the US Supreme Court to hear the case, once it gets to that possible level, the Supreme Court still says, we don't really want to do your case. We're fine with what the lower court has said, or we think this has already been decided. And so that's where we're at with the federal moratorium. But June 30th is an important date because that is when it is set to expire currently. There's been no official word. But I do want to talk a little bit about how the Court of Appeals got to the decision they got to in this case. So if you could roll the slide, Eric. Yeah, so the court looked at a lot of different things. And again, they thought about this seriously. And I don't think that anything that I'm going to talk about today isn't stuff that we haven't already covered before. But you know, somebody might be watching today that's never watched any of our webinars. We're on webinar number 52. I don't know whether it's 5,000 or 6,000 people that have watched these over the last 14, 15 months that we've been doing them. But I don't mind covering the same ground again because it is important. So number one, the Court of Appeals found, hey, look, let's just boil this down. If somebody gets evicted, they're more likely to be displaced. By definition, they are displaced. They're shoved out of a space that they're legitimately occupying, and they got to go somewhere else. So where is somewhere else going to be? And they actually talked about the fact that people might be going to shelters, transitional housing providers, but places where there would be a greater collection of people in a confined area. So they talked about that. They also talked about the fact, and this is important from a constitutional perspective, about whether the CDC really has the power to do this. They talked about the fact that people would be going over state lines if they're evicted. Not everybody, but some people would. And that's where the CDC's power really is shown and passes constitutional muster, is because they're regulating what we call interstate commerce. You might think, well, hey, a rental is a state only kind of jurisdiction, and in a lot of ways it has been historically. But if you force somebody to leave their home, chances are they're going to go looking for someplace else. They might move across state lines to stay with friends, family, whatever, because they know somebody somewhere else, which again might be a way that COVID-19 gets spread. The court also looked at the fact that in December of last year, Congress essentially rubber stamped this for a month. So the original moratorium, the original CDC moratorium, was once again during the Trump administration. President Trump was the first to do this. President Biden has made very little change to the CDC moratorium, just extended the dates. And again, President Trump's original CDC moratorium on evictions ended on December 31 of 2020. Obviously, we had an election, and we had lots of different things being considered in a giant bill that passed through Congress, the federal level, near the end of the calendar year. And one of the things was an extension of the CDC moratorium for a month. Congressional approval of the CDC moratorium. Now, one could argue, and the landlords in the Alabama Association case have, that Congress wasn't really seriously considering that 1 month. They were just extending it, but not really approving it, which is their argument. But the DC Court of Appeals said, that really does look like Congress saying it's okay. And so that seemed to matter quite a bit, and I think it should when analyzing this. The Court of Appeals at the DC Circuit level also took what I think is probably the most expansive and pro-CDC argument, analyzing the statute from 1944 that authorizes CDC to do everything it's doing under the eviction moratorium. If you read the original statute, it's hard to see exactly how this fits, because what it talks about is regulating transport of crops and livestock from one state to another. But there's also some really broad language used in that statute. And the court was indicating that, look, we need really broad language for the CDC to act in an emergency capacity when it has to happen. And so they gave great deference to that extra power that the statutes seem to give the CDC. And once again, the Court of Appeals said, more important than anything else, we think if there's an actual full-on hearing on all of this stuff, the CDC is going to win. That's what they said. And so that's where we're at right now. Again, the stay is in place unless and until the US Supreme Court rules otherwise, or the case gets sent back down or reheard. Lots of different potential mechanisms could be in place, most of which, to be direct, I'm not that familiar with. I don't work in federal court. It's just not something that I live in. And so I'm giving you an analysis after having read dozens of of things analyzing this issue over the last about 15 hours. But this is pretty much all I've been doing to make sure that I have a decent grasp on where we're at right now. But the Supreme Court taking the case up would be probably the next really milestone occurrence. But again, we've got this June 30th deadline. And if the president doesn't renew, or the CDC doesn't renew, I should say, the eviction moratorium, it becomes what we call a moot point. It's no longer a contested issue. So it might not ever get to the Supreme Court. I'm not sure how quickly they'd act. It's only 20 days away from tomorrow, when the government's supposed to submit their response to the landlord's request to have the case heard by the Supreme Court. So will we have an eviction moratorium at the federal level after June 30th? It could end two ways. One is that the president, through the CDC, does not renew it. The other is if I think the Supreme Court decides to step in and say, yep, this isn't okay. This is beyond what the statute authorized them to do. It's not constitutional. Those are the two ways that I see it ending anytime soon. From everything I've read, I haven't seen any declarations that the president would go longer than September. But we thought it was going to be September the last time that this was kicked around too. So our guesses are as much of a guess as anybody else's. Okay, so I think that is what I wanted to say about the CDC moratorium. We've covered the state moratorium, and Eric's going to touch on a couple logistics things, and then it's my favorite part of all these speeches, because I don't know what we're going to talk about exactly, the question and answer session. So.
All right, thanks, Mike and Michael, for covering those items. So we gave you an overview of sort of where the status is on federal and state moratoriums. And we got some questions submitted already and some that were sent in advance. So we're going to tackle some of these that got sent in advance, and then we'll move to those that have been submitted. We have until 3 o'clock. We got plenty of time here. So if you do have any questions about anything that we've brought up thus far, or other questions related to the suspensions or other pandemic, or just general Minnesota tenant landlord law questions, we'll fill up the time here until 3 o'clock, answering as much as we can. Okay, so, I do want to just note, I got a note from somebody saying that Minnesota Housing has announced that 211 will be able to do status checks for applicants on the renthelpmn.org rental assistance program. So I know that was a thing that some of our clients were running into, is that they maybe don't have internet access or reliable internet access, and so they can't check online. So now it sounds like you can call 211 if you've applied and get a status update on your application. Okay. First question is from Allison. If a landlord wins an eviction for a non-payment issue, can the landlord keep the security deposit?
Short answer, Allison, is maybe. In a lot of cases, probably. The security deposit can be used to cover two main things. One is if the tenant still owes something as part of the agreement, so that's typically going to be rent or utilities. or if the tenant caused damage beyond ordinary wear and tear. This isn't really about the ordinary wear and tear, which is most of the questions we get about security deposits. But yeah, a landlord could keep a security deposit to cover non-payment of rent in general, would be the short answer. They don't win it in that case, that the landlord doesn't get a judgment to go collect that money out of the tenant's bank account. It's not how our court is set up to do that. The landlord would have to go file a different case, probably in small claims court, to try to do that. But they would have a claim to the security deposit, and could, in most cases, keep the security deposit, send the tenant a letter saying, I'm keeping your deposit. Main reason is you didn't pay your rent for the last 2 months. You were behind. Your deposit was 1,000. Your rent's 1,000. You still owe me 1,000. But I'm keeping the 1,000 plus the interest to cover what you owed. And that would be, in general, legal. Yeah.
Okay. Aaron, who I think is a tenant, asks, what if we filled out the online application Rent Help MN and have heard nothing?
Yeah, I'll leave that one with you, Eric. You're the guy that deals with 211 and these questions more than I do. So
Yeah, so again, unfortunately, this is not something we can help with necessarily. I do know that there are, I believe you can go online and check the status of your application if you do have internet access. And if it still says pending, I'm not sure what else you can do at this point. And then it appears that 211 is now tackling questions about status for folks who maybe don't have internet access. But again, this is, we unfortunately can't help with that. It is one thing that we mentioned earlier, one of the reasons why we have been consistent and persistent in advocating for a end, if an end or an off ramp of the suspension, that it includes some key items such as adequate notice to tenants so they know they're potentially eligible, and then some timeline that is aligned with the fact that it's not necessarily easy to get hundreds of millions of dollars out the door to individual landlords and tenants. So that doesn't help you with your situation right now, but again, I think you just keep monitoring it, and hopefully they're moving a little bit quicker soon. Okay, Sarah, who I think is a service provider, is asking, as of today's webinar, the moratorium on evictions will end when?
right, and the question was submitted in advance. You might think it's kind of a repeat question, but I don't mind answering. This is the front page banner headline question that everybody should be asking about in landlord tenant world in Minnesota and many other states still. The short answer, the technically correct answer, is the state moratorium ends on June 14th. The federal moratorium ends on June 30th. Both of those could be renewed for more time. There could be legislative agreements in both cases, although I think at the federal level, that's very unlikely. At the state level, I think it's possible, but unless it happens, it won't be known. The state could be renewed for another 30 days, as it has been for 15 straight months. I'm not sure if that's the odds-on favorite right now for what's going to occur next week, but it is a possibility for sure, and maybe a strong possibility. So the short answer, Sarah, is we don't know when the eviction moratoriums will end. All we can tell you is sort of the facts as they are today, but they have changed frequently since last March. And so all we can really do is assess the current status of things and try to talk about what we've seen in the past and what the most likely indicators are, but that's as good as we can do right now.
All right, thank you. Okay, there's a different Allison from the first one asks, what can a landlord do if the tenant won't apply for rental assistance? So I did mention, did you want to jump in, or?
No, go ahead.
I did mention, and I did put a link in the chat. I'll do it again. If you are, sorry, trying to find my notes here. If you are in Hennepin, Ramsey, Dakota County, there is this new program that is called the Zero Balance Project.
Just a couple slides forward, you have another.
Oh yeah, thank you.
Sure.
Um,
Throw it up on the screen again.
yeah, so there we go. Zero Balance Project. The link that I just put in the chat will get you to Housing Link's website, who I believe is helping to administer it. And there's a lot of information on that website. And then at the bottom is where you can apply. So that's actually a program that landlords are allowed to start the application and move it along, and then the renters are notified. More broadly about that question, I don't know if you have anything more, Mike. Or...
Yeah, I do. A couple things. First of all, nothing about this is intuitive, right? Tenants aren't sitting at home thinking, oh, I get free money necessarily. They might have heard of it, but there's nothing intuitive about it. These are completely unprecedented times in a lot of ways. And so when a landlord says, what can a landlord do if the tenant won't apply for rental assistance? A couple things that I'd talk about is that the landlord can help sell this concept. Maybe they've looked into it. Maybe they're using the Zero Balance Project, whatever the process the landlord wants to use, but they should tell the tenant, hey, look, there's real money out there. It's available to you to use to pay your rent so you can get current on rent and stay in your home, which is truly a win-win for both the landlord and the tenant. But we have to apply together, right? I can start the application. That's what the Zero Balance Project is helping landlords do. Or I can sign whatever you need to be signed if you want to go through Rent Help and provide whatever documents you need. But I want you to get this money sent to me just as much as you want it to get sent to me. Now, the tenant you might think that the tenant doesn't care. Hey, they've had free rent for 3, 5, 10, 12, 15 months, so they don't care. And maybe that's true with a few tenants. But I can tell you, having talked personally to these tenants, both over emails and on the phone, we can hear in their voice that they are just terrified of the whole situation. And they don't know exactly how to proceed. The rent help process, while it's great that there's a ton of money, isn't the simplest process in the world. And it takes a little bit of diligence on the tenant's part. Whatever help a landlord can give in that regard, again, is good for the landlord and the tenant, assuming, of course, that the landlord wants money, which is the only assumption I've ever made about every landlord I've ever dealt with since I started working at Homeline in 1996. Some landlords are great people. In fact, most of them are. But all landlords want to get paid for the fact that they're housing somebody, or otherwise it's not a landlord-tenant situation. By definition, landlords charge rent. They want to get paid. It's a business. And this is a way for the landlord to get paid, even if the tenant owes a lot of money. And so again, this is an unprecedented time, and we're going to shift. At some point, the eviction moratoria, both of them, are going to go away. We don't know when. Is it going to be June 30th? So July 1st, a landlord could go file an eviction. Is it going to be that fast for non-payment of rent evictions? Maybe. Maybe it'll be October 1st. Who knows? It's very difficult to glean all of that. But at some point, the table will shift dramatically, because right now the landlord doesn't have the one hammer in their toolbox that has historically mattered the most, which is they could go file an eviction if they needed to. They can't do it. But at some point, that hammer is going to be back in the toolbox. And so right now, a landlord saying something like, hey, go apply for rent help or I'm going to evict you. Tenant tells me that story, I'm going to tell them to call the Attorney General's office to file a complaint against the landlord because they're not doing what they're supposed to be doing. But when the eviction moratorium goes away, then that's a different situation. The landlord can go back and say, wow, it looks like you're still behind 6 months of rent. Have you applied for rent help? Now, a temptation for a landlord here, in fact, I think a consideration for a landlord attorney, which I'm not a landlord attorney, I'm a tenant attorney, but landlord attorneys are at some point going to get flooded with calls because the doors are going to open and landlords are going to call them up, the landlord attorneys out there, and they're going to say to them, I want to go evict. The tenant hasn't paid. They owe me a bunch of money. Let's get them out of it. And that's a way to go. It is a way to go. And at some point it's going to be legal, but it might not be in the best interest of the landlord. In fact, in most cases, it won't be, because once the tenant is gone, once the landlord wins the eviction and wins back possession of the rental, they no longer are likely, the way we've heard the program described from everybody that we've asked about this, that the landlord can no longer get that money from the tenant. The money won't be used to pay back debts if the tenant is vacated. What it's used for is to stabilize the housing, to make sure that they're caught up in their current place. So a landlord chasing a tenant out, there's a cost. You might not ever see the money again. And you could chase the tenant later, right? Go file a case against them for $1, $5, $10, $20, $30,000, whatever they owe. That doesn't mean you're ever going to see that money as a landlord. If you want the money as a landlord, working with the tenant through the process to try to qualify for the money is the best shot for everybody. And I think that these programs have been designed that way on purpose to try to help stabilize people's housing instead of just to get landlords whole. Making landlords whole is part of the equation, but it's only if we can make the tenants' housing stable at the same time. Seems to be the impetus behind the programs that we have. And so I think Allison's question is, hey, look, I want the tenant to apply. How do I convince them to apply? And once again, it's trying to sell to the tenant. It's in your best interest to get this paid off as soon as you can. And as I mentioned, once the moratoriums go away, there's going to be a line at every courthouse in the state to go file evictions. But it might not be the best decision for a landlord to rush down to the courthouse to go file an eviction because they might be winning the court case, but losing the money. And so it's a consideration that I think every landlord is going to have.
All right, thanks, Mike. The next thing that came in was from Barbara, and she didn't have a question. She just said, thanks so much for doing these programs.
Well, that's
Thank
very
you,
nice. Thank you, Barbara. Appreciate you saying that. Thanks.
Thanks for joining us. Submission from an anonymous. Are lease non-renewals included in the off-ramp, or will landlords be able to non-renew at the end of June or July?
Maybe the non-renewals would be included in the off-ramp. It's hard to know exactly where these things are going to land. If I had to bet, if there is an off-ramp, it's probably going to include non-renewals, but I don't know that for sure. Right now, the status that we have in Minnesota, a landlord cannot non-renew a tenant or give a notice to vacate. If the tenant is month to month, for instance, they can't just give a month's notice under the current rules. It's not just an eviction prohibition, it's an eviction it's a prohibition of evictions plus terminations of tenancies. And so it's really broad, the governor's executive order on that. And I have contended since last summer that right now we have a higher percentage of tenants in Minnesota that have month-to-month leases than any time, certainly in my career. Normally, in a lot of leases, a lot of landlords at least like to start with a 1-year lease. And then if the tenant sticks around, they'll roll over into a second year. Some of the time they won't, they'll just go month to month after that. But I think a high percentage of landlords have rolled over into a month-to-month lease instead of renewing for another year because they weren't really sure about where the footing was with everything in the world. And so they opted for more month-to-month leases. So I think we have a higher percentage of month-to-month leases right now, which is less certain for both sides, frankly, because either side could give a notice to vacate in that regard.
Right. So another question, just when does the off-ramp start?
So there isn't really an off-ramp yet. The off-ramp is the proposed legislation that we've been talking about. Michael spoke about that earlier and how it's a lot of rumors and nothing really concrete. I mean, there are concrete proposals, one from the Senate, one from the House, and there's something to that, but unless and until the joint houses of Minnesota present something to the governor and the governor signs it, it's all speculative. And so there isn't really an off-ramp description that we can give that means anything because it's all presented by either the Senate or the House and not really agreed upon by both chambers. So there isn't currently an off-ramp in place. Like we've talked about before, eventually, and this is a question that looks like Beth just submitted in the chat that's really on point with what we're talking about. If there's no off-ramp and the CDC moratorium goes away and the peacetime emergency goes away, meaning the eviction moratorium in Minnesota goes away as well, it's not going to be an off-ramp. It's just going to be one day you can't file an eviction, the next day you can. And we're going to reopen the courts and be business as usual with the old rules in place. So that's where we'd be. It wouldn't really be an off-ramp. It'd be more of an off cliff, I guess. If you need to have some sort of symbol in mind, that's what it would be versus an off-ramp, which would be a somewhat gradualized approach to what can happen and when.
All right. Another
Yeah, the
question.
other addition I would just want to add to that answer is that it is also possible that the governor could continue the peacetime emergency, in which case, um, the moratorium would continue with it. And thus far, the governor has stood strong on both the peacetime emergency and the moratorium being attached to it, and so it's that's another outcome that could keep people housed.
All right. Okay, so I think we maybe got a question. Sorry, give me a second here. No, okay, let's do this one. Beth, who's a service provider, sent again. We're still doing ones that were sent in advance. So and we got plenty of time. So you have more questions, so go ahead and send them in. But Beth asked, what jurisdiction do the courts have to implement temporary measures not included in a legislative off-ramp?
They have some authority to do some things different. An eviction is a statutory creation in a lot of ways. So the legislature created it and asks the courts to enforce it, is basically how it works. But there are also court rules in play as well. And so the court has ultimately the discretion over that. In some states, we've seen state Supreme Courts issue kind of rules about how to conduct things when it comes to evictions. Certainly that was true of the CARES Act when that came out. That was the original monetary aid package that was produced last spring, and it also had an eviction moratorium built into it. That was our first federal eviction moratorium. It wasn't universal. It didn't apply to all tenants in the United States, but it was a lot of them. And so there were some states that issued mandates from their courts, generally handed down from the state Supreme Court, saying, hey, here's what this means here, and this is what you have to do to follow it. And so courts do have the right to interpret what the rules are. That's really what their job is, along with enforcing the rules. And so that's possible that we could see courts trying to figure out what the rules are / should be as part of this. So yeah, that could play a bigger role than it is currently.
Yeah. Okay. There's a couple that came in via the chat here that I'm going to capture, and then we'll move on to those that are in the Q&A box. Somebody asked about, is the Zero Balance project in conjunction with Rent Help MN? I think to a certain extent it is. If you go to that website, which again, I had just put a link to the Zero Balance project information website in the chat, it does say that if your renter, if you're a landlord and your renter applied for Rent Help MN anymore, or if they already did, they can only receive assistance from one program for the same months. So you should stick with the program that they already applied with. But and apologies, I'm not 100% up to speed on this, but I do believe a lot of the money for these two programs, both Zero Balance and Rent Help, are similar. They're just kind of designed in different ways and for different locations. Again, Rent Help MN statewide, and Zero Balance only Dakota, Hennepin, and Ramsey counties. And then Pat in the chat asked, are there any laws to stop the increase of rent gouging because this is creating more homelessness?
Yeah, so there still is. The governor's, there was a very early order last year that the governor issued, an executive order that stopped price gouging for necessities. Housing was considered one of those necessities. So if a landlord raises a rent more than 20% of what it was back in March of last year, then yeah, I think that would be a violation of the price gouging rule. A tenant should complain to the state attorney general's office about that. There's actually a pretty serious penalty built into it, more substantial than violating the eviction order rule, in fact. So it is something that we've passed on to the AG's office many cases on, and I'd encourage a tenant to do that if it's above the 20% for sure.
Okay. All right. Let's get to some of these questions that have come in now. We kind of addressed this one already, but Ches, apologies if I'm pronouncing your name wrong. When will Rent Help start processing applications? I have clients who applied April 20th. That April 20th is the day that Rent Help MN launched. And anyway, and he says that those that applied on April 20th, they're still pending review. There's no updates to applicants. Yeah, I'm not sure what to tell you there. I do know it's now 3 weeks ago, maybe. I'm looking at the calendar. Maybe it was at the end of May, there was a legislative hearing that happened for the working group at the legislature that was tasked with finalizing the housing budget and the housing policy bills and the off-ramp bill. And they had a legislative hearing where Minnesota Housing did present. The commissioner of Minnesota Housing, Commissioner Jennifer Ho, presented, and I think this was reported in the Star Tribune that at that point in late May, they had started processing. They had processed and got out checks, or not checks, but they had paid on behalf of about 200 applicants, and it had been around $1 million. So that was towards the end of, I can't remember the date, I apologize, but at the end of May. So they are processing, and if you need more information, you should check the applicant's page. Anonymous question: has there been any guidance to landlords who were unaware of the executive order prohibition against notices to vacate specifically, and then they sent out a notice to vacate, but later want to remedy this potential violation to avoid the penalties?
Yes, interesting question. Basically, what this question is asking is kind of an age-old legal question, which is, does ignorance of the law, I guess the law in this case, give you an excuse that you can use to say, oh, I didn't know, so it's not my fault? The example I frequently give is if you try to convince a highway patrolman who stopped you for speeding and you say, yeah, I saw the sign that said 55. Do you know how fast you're going? 70. Yeah, but I didn't understand the sign. It didn't make any sense to me. That's not going to work as an argument. That sign is obviously really in our faces versus a lot of the laws that we might not be familiar with. In fact, I don't think anybody's familiar with every law in this state. There's a lot of laws. There's a lot of laws in every state. But in general, the general rule is ignorance of the law is not a defense. That being said, practically the enforcement of this rule, the executive order from the governor, relies on the state attorney general's office. And while I don't work at the AG's office, I know some people that do work there, and we've been in a lot of contact with them since this all started. In various times, we had Catherine Kelly, who's an assistant AG, on our program about, wow, I don't know, 10 months ago, talking about how they were enforcing this. What we've gathered that they do is they get a complaint from a tenant about something that the landlord has done or threatened to do. And they call the AG's office, and then the AG's office contacts the landlord and says, hey, not sure if you knew about this rule, but you can't do X. This is what the tenant says you tried to do. Are you going to back down, or do we have to go after you? That seems to be how it happens in most cases. Now, I'm sure that there's some cases that are much more egregious, but that seems to be what the AG does in general. And they can't chase every landlord that does something wrong. They want to talk landlords out of doing things wrong. It's a lot more efficient for them, and they just don't have the staffing to prosecute every case. So can I guarantee the AG won't come after a landlord hard for doing that? No, but I don't think that's been their general approach here, partly for efficiency, partly because of the reason why the question's asked, which is there's a lot of rules right now. In fact, I can remember when Eric and I talked about giving these speeches starting in April of last year, and we were just sort of theorizing about what we should talk about, how we should present these. The reason why we wanted to do them, to present it to landlords, to tenants, to social service providers, to government officials. We've had people watch from the courts, from the AG's office, from all around the state at a lot of different levels. And why we wanted to do this was we wanted to be able to summarize what the rules were. We're talking a little bit about sort of potential off-ramps, but what we have focused on almost exclusively since we started doing this is an explanation of what the rules on the ground are. And that's not necessarily easy to do, because the rules have shifted so much. I work in landlord tenant law, which generally, if I'm talking about the laws are, they don't change much at all, if ever. I mean, you could argue that the majority of our eviction system, our court eviction system, was largely created, including the timelines, before Minnesota was a state, before the Civil War. Law in landlord tenant law doesn't change a lot. It just doesn't. But everything changed when COVID-19 hit. There's federal rules, there's state rules. They've changed multiple times. And so that's why we give these presentations, is because we want people to know what the rules are. That's really what we're trying to do, is inform folks so that they have a good sense of what actually is. We talk a little bit about what might be, but we're really not good at guessing this sort of thing. And it wouldn't make much sense for us to try. So we just talk about the things that have been proposed, and where things are with court cases, where they are with executive orders. But there is a lot of confusion. So I sympathize with tenants that contact us and say, hey, because there's a tenant calling us right now on our tenant hotline saying, is the state moratorium going to get renewed next week? I don't know where am I going to be homeless next week? They're going to ask us that exact question, not realizing that the CDC moratorium might be a backstop that they could use, not realizing that it might get renewed for another 30 months. They've just heard somewhere, maybe their landlord told them, maybe it was a rumor, maybe they saw it on social media, that the eviction moratorium was going to end. And technically it does end every month. And it has done that every month for 14 months. But tenants aren't necessarily aware what the rules are. Landlords aren't necessarily aware of them. It is a complicated and confusing time, legally speaking, on what the rules just are. And so that's what we're trying to do here.
All right. Okay, kind of a two-part question here from Sherry. Has there been any discussion for off-ramping when on month-to-month leases, whether a tenant might be eligible for a longer notice to terminate a lease, other than the normal 1 month plus 1 day? And then Sherry also sent in, my question would also add, if payment is current, and if that's not an issue, any likelihood of protecting tenants from getting non-renewal notices for the 30 plus 1 day to end their lease?
Okay, so and leave the questions up for a second, Eric, so I can keep an eye on them. There's a lot built in here, and there's sort of this is a very informed question, clearly, that Sherry is asking about. So I'll start with some basics. First of all, most leases have a termination requirement of some type in Minnesota. Most written leases do, and even oral leases do, handshake agreements. The 30-day plus 1 day to end their lease mention that Sherry talks about is close to right, but it's not exactly right. It's typically a full rental period's notice. And why I'm not just trying to be a lawyer here and say, oh, 30 days is not a month. February's got 28, several months have 31. So it's a full rental period's notice. And let me just tell you sort of the standard non-pandemic time rule. If a tenant wants to give a notice to vacate, or if a landlord wants to give a notice to ask the tenant to leave, the normal rule is, in most cases, on most leases, that the one side has to give the other side written, has to be in writing, and properly timed notice. Now, if it's a 1 month or one rental period notice requirement, that typically means that you can give a notice anytime during 1 month to vacate for the end of the next month. So today's June 9th. You might think, well, if I give a 30 plus 1 day notice, does that mean that the tenant has to leave? If I'm the landlord giving a notice, that the tenant would have to leave on July 10th? No. We care about when the rental period begins. That's why it's a full rental period's notice. Every rental period for most tenants starts on the first of each month at midnight 01, right? So once that rental period is begun, and we're in the June rental period right now, then a notice can be given for the end of the next rental period. July 31 is when it could be given for, no sooner. And it shouldn't be given for August 1 either. That should be, one full rental period's notice. And so it's a common issue that comes up. In fact, tenants don't frequently ask us about this when they call us, but we always talk to them about the particulars about the notice to vacate that they got. If a landlord gave them a notice to vacate, we ask them very basic starting details. When did the landlord give you the notice? How did they give you the notice? Was it in writing? Was it over the phone? How did they tell you that you had to go? If it was in writing, can we see it? And what does it say? And we look, is it properly timed? And so a starting point to this question is normally a landlord can give a notice to vacate for the end of the next rental period, assuming we're on a month-to-month lease. So can a tenant, by the way. They can also give a month's notice or a full rental period's notice if they want to leave at the end of the next month. And kind of the deeper question Sherry's asking is there a conversation about whether a tenant could get a longer notice in that situation? And again, notice is something that's tied into both the Senate and the House versions, but I don't know that there's a guarantee in either one that question would be answered, that you'd have a longer time frame necessarily. And I don't have them right in front of me right now. Michael, do you remember from what you have in front of you, if you have those two, whether the notice would apply, that question from Sherry would apply in that regard, if you're still with us?
I don't have the answer right at the tip of my tongue right now. Sorry to
okay.
say.
Yeah, I know that there's no consensus on it. There's no consensus between what the Senate and the House version has regarding that.
And I'll
but it's
put,
yeah.
I was just gonna say, because I did it last time, I'll put in the chat links to the last language on both the House and the Senate side. Of course, that was from the end of session, which was May 17th. Yeah, May 17th. And there has been negotiations since then, some of which has been reported on by the news, some of which hasn't. Some of it was actually discussed at the press conference this morning, what some of the offers had gone back and forth. But I will put just those two bills in the chat so you can look at sort of the base of what each the House and the Senate had proposed. Was that it then?
I think so.
Okay. Okay. Yeah, Sherry asked, but it is under discussion. It may be.
I don't think that it's the
I think-
primary sticking point between the sides. I don't think that's the only thing they're fighting about it. I don't think that's what's holding a deal back by any means. Yeah.
Okay. And then I don't know. Did you want to mention what Kim said here, Mike?
Oh, let's see here.
Kim is saying she thought. So go ahead. Did you want to go ahead?
Yeah, Kim Tennyson, who's an attorney that works with landlords and has been on our presentations a couple times over the last 15 months, mentions that she thought that they contemplated a pre-filing notice of potentially 30 days, which would still require notice to vacate before the ability to file for holding over. Yeah, again, there's the two different versions. And as I mentioned, I don't think this is the primary sticking point. And it's been much less of our focus in what we're sort of reviewing and trying to figure out what it means and what it says. But again, we don't have a deal in place right now. It's possible that it will have something included like that. Yeah.
Okay, so excuse me, Greg has a question here. A landlord says, my tenant is month to month for the past 14 months. Can a landlord offer the tenant an amount of money to leave the property?
Yeah, I think so. And we've seen the landlords do this. I don't think they've done it as much in the very recent past, in the last few months. I think the sense is that everybody has that the moratoriums are going to end at some point. Sooner than later, I think, is the hope for landlord groups, whether it's a court or just COVID goes away, right? Which we all want to have happen for a zillion reasons. So I don't see it as often as I think we used to hear about it from tenants. But yeah, I think a landlord and a tenant can negotiate to end the lease early if the tenant wants to take an offer from the landlord to leave early during the moratorium. They can. Once again, a landlord needs to really try to balance the reality that they very well might not ever recover the money that the tenant owes in exchange for getting possession of their place. And it's a big decision that once the moratoriums go away, landlords are going to have a big decision that they'll have to face from a business standpoint. What's my best bet? Is my best bet to chase this tenant out that owes me a bunch of rent? Or is my best bet to work with that same tenant to try to get the money through rent help and get covered for everything that I've lost up to this point? And in many cases, it's going to be the second option, but it might not be what landlords feel like they want to do because they feel like, hey, the tenant hasn't paid. And we've heard from landlords on these sessions, you know, I've got tenants that are just refusing to pay. They've got tons of money. They could pay if they wanted. They just choose not to. And I'm sure that happens in some of these cases, but in so many of the cases, tenants have lost their job. They had to stay home to watch their kids while they were homeschooling, and then they lost their job. Somebody got sick. They had to help take some care of somebody else somewhere else. And so if landlords want money, working with the tenant, waiting for rent help to finally start paying off makes sense. And again, the rent help money is not wished for money. It's not, we're hoping it's there. It's real dollars that have been authorized by the federal government. I think it's in the state's bank account, whatever that looks like physically, I'm not sure. But I think they actually have the money in hand. So this is real money that's going to get paid out to landlords. And so my hope is that landlords think, I want to get my share of that money. How do I get eligible? And how do I help this tenant apply? These truly are, when in most landlord tenant situations, and this is what I honestly believe in my heart, I'm not just a tenant advocate right now. These truly are the best outcomes they're going to be the best outcomes for almost every landlord tenant where a tenant still owes money. And I'm hoping that there's enough money at the end of the day to pay everything off. It looks like there's a giant boatload of money. Just they're figuring out the process. As Eric has mentioned, it's hard to give away millions of dollars and do it right. I mean, if let's say it's $700 million or whatever number it is, if they wanted to just write a check out to the first, 700,000 people that ask for $1,000, I guess they could do that. But that's not really going to help anything. They need to figure out how to make sure that people are qualifying correctly, so they're paying money to the right party. They're not double paying. They want to have all the safeguards in place to make sure that it's done right. But once the money machine starts flowing, then my hope is that the torn up relationships between landlords and tenants over the last 15 months can get mended quickly because the landlord gets made whole. The tenant can start paying their rent because hopefully they've started back to work. And on a monthly basis, they'll be able to cover their bills like they used to. That's what we all want to see happen. And hopefully that will happen. But yeah, it does ask the landlords for some patience. It just does. And I hear from landlords and I understand, hey, look, you're trying to make your bottom lines too. But hopefully it will, in the end, get made whole, the bottom line for landlords.
Yeah, and I mean, you mentioned one of the things that they've got to make sure people qualify and everything like that. We've talked about this there, and we had staff from Minnesota Housing on like in March. Was it March? In advance of the program opening up, and they were saying it was all dependent on federal guidance, Treasury guidance. So that's another thing they're working with. But I mean, you mentioned that it's a boatload of money. It reminded me it's that boat that was stuck in the Suez Canal. It's that much money. It's that large of a boat, and it's stuck kind of. But it is starting to flow. Okay, there is a question. Okay, an anonymous question. What if both?
Did you have to use that image?
Sorry. I mean, the boat, that Suez Canal boat did get moving. So
yeah, yep. I get it. It's just kind of a sad scene. All this might that humans have and not able to move that boat for a while till a little tugboat ant comes along and helps. Wasn't that how they did it? A couple tugboats solved it?
Something like that.
Yep.
Okay. An anonymous question. What if both the House and the Senate do not agree to extend the peacetime emergency order if the governor decides to extend on 6/14? So again, 6/14 being next Monday, and the news, NPR already has been reporting that Walz said yesterday he is going to extend it 30 days. But the question is, what if the House and the Senate both do not agree?
Well, then I think the eviction moratorium goes away. So then all we'd be left with for the question about evictions is the CDC moratorium, which doesn't go away till June 30th and could get renewed. And again, the CDC is just about non-payment of rent evictions. So it's much more limited than the state version, which basically says you can't evict except for a few exceptions. We haven't talked about those exceptions today, but briefly they are: if the tenant causes significant property damage, they seriously endanger others in the property, If they violate an old statute that says that a tenant can't have drugs, guns, prostitution, stolen property on the property, or if the owner or a family member needs to move in and it's not mid-lease, right? You're not in the middle of a 1-year lease. The landlord needs to move in to retake possession personally or a family member. Those are the only exceptions that we have, whereas the CDC moratorium just says you can't evict for non-payment. So we'd still have something in place at the federal level, and it would still stop the vast majority of evictions from being filed in Minnesota. But we'd have to convert over to following the CDC rule. And as mentioned, in Minnesota, we haven't really focused on the CDC rule at all. But within minutes of that happening, if the state ended the eviction moratorium, we would be, let's say it happens. Let's say it happens this week. Next Wednesday, we're going to be talking about for 90 minutes how tenants comply with the CDC eviction moratorium to make sure that they're taking the steps necessary to protect themselves from being evicted for non-payment of rent under the CDC order. Because right now we just don't focus on that at all.
All right, we've got 10 minutes left and about a half a dozen questions. So this is the lightning round. Again, I'll put up on the screen that we are doing this next week because there may be news as the legislature gets back together on Monday and maybe probably longer than just next Monday. So you can tune in next Wednesday. I'll put the link in a second. Anonymous question: has the governor been involved in any of the negotiations or legislative discussions regarding the eviction moratorium off-ramp?
Michael, I'll leave that one to you.
The governor's office is certainly being consulted when there are serious offers that are flowing back and forth, but the primary actors, the people that are supposed to be making the decisions, right, until just very, very recently, were the legislative conference committees set up to handle these housing issues, and then that decision would then be for the full House and Senate to decide upon. But right now, the decision has been sent up from those committees to leadership, and that leadership includes the governor's office. So yes, the governor's office would be involved if things continue as they have for the past several days. The only thing that I would add is that we know that chairs of the committees are going to be meeting with leadership fairly soon to talk about the parameters of where the decisions have been made between both parties and they agree, and that will be taken under consideration by the parties.
Okay, I'm going to jump to Beth's follow-up question here in the chat. In the event the House and Senate agree to allow landlords to file when the tenant's not eligible for rental assistance, who has the burden of proof, and at the time of filing or at the time of hearing? It seems like a reasonable approach, but I don't know how implementation would work.
I think that's been kicked around in the negotiations, who would have to assert it, whether it would be the landlord would have to assert that the tenant hasn't done everything, or whether the tenant would have to show somehow that they've done everything. In general, in the law, it's up to somebody trying to prove something to prove it versus disproving something, but it's not always the case. But yeah, it's something that's being negotiated.
Okay. All right.
There certainly is not an answer to that question yet. There's differing viewpoints on who has the burden of proof in both the House and the Senate offers.
But it does just create, I mean, as has been discussed, it creates some complications, especially with, that people have been sitting waiting to see if they are going to get approved. And then if they get denied, they do have I think there is an appeal process. If you don't agree that you got denied for rental assistance because something went wrong, I mean, there should be some timeline there. So, okay, okay, Pat Long says, thanks for doing this for the communities. Thanks, Pat. Okay, anonymous question. A landlord I am working with is in a purchase agreement to sell a multifamily building contingent on an empty building. Building needs significant upgrades. Seller knows they cannot non-renew any tenants or of course evict, but can they send notice to the tenants letting them know of the sale and that they will have to move as a result? Non-renewals / evictions will not happen until it is legal to do so, but seller would rather let tenants know sooner rather than later that they will need to move so they have as much time possible to find a new place. But we are concerned that sending the type of notice will appear as a non-renewal and therefore be in violation of current rules. It's
a complicated question. And I'm not sure I have a great answer here for you. This is clearly somebody advocating on behalf of the purchaser, I think, of the building. And they're trying to figure out how to do this right. And it sounds like they're just trying to be as open with the tenants that are there as possible. I suppose it would depend somewhat on the wording of what the notice says. First off, I would recommend no notice be sent until the sale actually happens. I don't see much of a value in doing that in advance, because sales fall through. They just do, sometimes at the very last second. And so the new owner saying, hey, I'm going to be your owner in a week, and as soon as I'm able, I'm going to make you go, just kind of summarizing what was just said. I wouldn't do that. There's nothing to gain by doing that prior to actually owning versus waiting that extra week. Well, let's say the sale has actually occurred. Would it be smart for the new owner to say that? There are some cities where there might be some rules about disclosures, Eric, and you know a lot more about these rules when there's a transfer of ownership. Can you give a handful of the cities that you think that this would be something where they'd want to look at the ordinance to start with?
Minneapolis has one, St. Louis Park, New Brighton, Richfield. There's more. There's a question actually in the chat that's about the St. Paul. So I don't want to complicate the issues. There's a list of them. So if you're in the metro area, you should check what the city rules, city ordinances are around apartment sales and notice, advance notice.
Yeah. So the short answer is it would have to be a very carefully worded thing. And I can say that we've seen notices from owners like that are kind of these tentative notices to vacate. And from our perspective, what we do is we tell tenants to just call the Attorney General's office to see if they think it's a violation. And ultimately, they'll try to decide whether they think it is. And it might be.
All right. So there was a question came in about St. Paul, since it kind of just came up.
Yeah.
Any updates on St. Paul City Council voting to repeal safe housing ordinance? Are there ways to support City of St. Paul if they do decide to keep ordinance and try to appeal in court? So I was actually quickly looking that up. I believe at 3:30 today, today's June 9th, right? Yep. At 3:30, the St. Paul City Council is meeting. I think they're still doing virtual. Maybe I'm wrong. Apologies if I'm wrong, but ordinance 21-21 is the ordinance that will repeal chapter 193 of the St. Paul ordinances. That includes a advanced sale provision, but a bunch of other things. The reason for that was that there was a lawsuit that at least at the first court battle over it, the city looked like they were not going to win. So they've decided to repeal the ordinance. And my understanding is, so you can submit, you can actually, I think, maybe speak, or maybe you can submit written public comment. I think it's the second reading of the repeal. And then my understanding is that their intention is to repeal it, but that there's a lot of interest among the council to rework it in a way that does not create some sort of legal challenge. So so I don't have all the details on that, but it is, I'm pretty certain, happening today. At least a public hearing is on it. Okay, and then, oh, we got an update from somebody in the chat. Rent Help MN will provide applicants a status of their application. A recommendation is that tenants and landlords keep those types of notifications for proof. So if evictions are allowed to open up and it says pending, maybe you're safe. Maybe as long as you keep that evidence, maybe you're safe as long as it's pending. But there's no.
We're thinking screenshots or print it out, or what would you recommend?
If Justin wants to mention that in the chat. I think probably
Maybe both.
maybe
What's
both.
the downside?
Whatever,
Yeah.
whatever you can do. Okay. Yeah, whatever you can do. Justin agrees. Take a picture with your phone.
Sure.
Katie says, can you repeat what was said in the press conference earlier this morning? I cannot.
Actually, you could repeat your part.
I could do my speech. It was very hot. It was in person, and it was hot outside the Capitol. Maybe you're asking specifically what was said about what negotiations has happened. I'll kick it to Michael to if we can share anything. I couldn't actually hear a lot of it, so I would assume there will be some news reports. There was plenty of cameras there.
So this was primarily this Minnesota House presenting its case and saying that there ought to be a timely, orderly off-ramp that has a longer timeline so that people can actually get the assistance that they're applying for. There was an offer that came in and was talked about at the press conference from the Minnesota Senate just about 20 minutes before the actual press conference. And while there were a couple of concessions, generally the House members were not that pleased with the response because it tied the off-ramp for the eviction moratorium, not only to just addressing that issue, which was the Senate's position they also wanted the Senate's position on appropriations of state fund appropriations, as well as bonding for housing infrastructure bonds. And so it was, I think, it was not received well, and negotiations need to continue for this to have some sort of meaning.
Thanks, Michael. And Julie, who is with 2-on-1, I believe, is saying there's a confirmation letter that can be printed from the application page on Rent Help MN. This can be shared with a landlord or others to show proof of a submitted application. Okay. Did we get to everything?
You know what? My access is limited, so I can see a picture of you, of me, and of Michael, and that's all I can see right now. So I don't know if there's anything more. I'm going to trust your eyes.
Okay, well, I did put the links to next week in the chat. Maybe we'll have more news a week from today, or we'll just be kind of doing this whole thing over again on the 16th. But I think people have plenty of questions, so we're happy to continue to do it. Again, here's the Rent Help MN website and 2-on-1 and the New Zero Balance Project. Anything else from Mike or Michael? No? Okay, well, thanks everybody for joining us, and maybe we'll see you next week. Goodbye.